Councilman Hodge had asked me to call him on the conference call. Do you want me to call him before the meeting starts?
You can call him. I have him waiting because I'm about to call him meeting order. So.
Oh, okay. So I'll call him right now. I'll need to get over. I need to dial in right here. Sorry.
I had it this morning and it's gone. It's just gone.
Okay, he should pick up.
Me all day today.
I emailed him, told him I was going to call him now.
Is that what it is?
Are you supposed to call him? He's going to call you back.
Actually, no. We emailed him to let him know that we're going to call him so he can get in the reception area. Email me back. He's going to pick up.
We're sorry. All services are ended now. Please try your call again later.
Where is he? Is that a redial? That's right.
He emailed back and said, yes, go ahead and call me. He emailed back, yes.
Why are we on?
Turn it up.
Hello?
Hello?
Nothing hard.
Hello?
All right. You hear me? All right, we're about to convene a meeting, okay? Thank you. Let's call the special council workshop meeting to order. Tuesday, January the 17th, 2006, right at 5:40 p.m. Present is Councilwoman Bell, Vice Mayor Losner, Councilwoman Roman, Councilwoman Garner, Councilman Porter, and we have Councilman Hodge on the phone from Chicago, right? Councilman Hodge? All right. The business of this evening is the presentation of the Redland Company concerning termination of its license to use 62-acre site, City Lake, south of Southwest 344th Street for evacuation of field material. Who's going to make the presentation? Mr. Muns, you?
Hello, Mike.
Good evening. My name is Carrie Barsh. I'm an attorney with offices at 1221 Brickell Avenue at Greenberg, Troy. I'm here on behalf of the Redland Company, and I'm joined tonight by Mrs. Munns, Mrs. Hollander, and Mr. Knoll. And if I could tell you a little bit about myself first, I am an environmental and land use attorney, and I have some special expertise that relates to rock mining. I represent a number of the rock mining companies that operate in the Lake Belt. And I'm here tonight on your special item, to talk through basically and address questions that you may have. As you know, this item is in response to a termination of the city of a prior agreement. What we are proposing and requesting that you consider tonight is a reconsideration of that prior action, rescinding the prior termination, and also authorizing your city manager and city attorney and staff to negotiate and put into the detail the terms of a supplemental agreement that would address what we think address some of the prior issues that have now come to before you. I'm going to be assisted tonight by Mr. Munns. I'm going to walk through that. As you all probably know, there have been some mistakes that occurred at the site. The purpose of our being here tonight is to talk about how those mistakes can be addressed. And principally, we proposed a supplemental agreement that would be an amendment to your prior agreement that would be comprised of 3 different areas. The last would be kind of a monitoring plan, and I'm going to walk through these in more detail, which would be a series of, I guess, additional actions, proactive measures that would provide additional protection and communication with the city and its staff to eliminate and minimize any chance of mistakes occurring in the future. Another important aspect of this would be a bond, the payment and performance bond of $2 million, which would provide for additional protections in the event there would be any other issue with regard to our compliance with the agreement. And the first measure would be a series of indemnifications that we would provide for the city in connection with the cease and desist that was issued by the county through its agency known as Durham. So if I could, I'd like to walk you through each of those and then answer any questions that you may have. So, Mr. Munns? The first part is what we propose is to indemnify and hold the city harmless as follows. For the cost of the as-built survey that was required by Durham through the cease and desist, for the cost of chloride testing that was similarly required by Durham, and this testing would include the testing of the lake, the testing of existing monitoring wells, along with any additional well installations testing that would be required in connection with the cease and desist, including any cost of the city to implement these things. The next thing would be we would indemnify and hold you harmless for the cost of any additional engineering-related expenses that would be incurred by the city in connection with this. We also would actually, as we go through here, we would indemnify for any cost of remediation to meet the requirements of Durham pertaining to the over-excavation of the lake. We would also indemnify you for the cost incurred to any other governmental agency requirements that may be necessary, that might be imposed in connection with the operation of the Homestead quarry. We would also indemnify you for any damages suffered by the city to the extent there were any as a result of any delays associated with the providing of the fill to the Shores Development. I understand there's a representative of Shores Development here tonight, so if you all had any questions, the representative may be available to address those questions. Also, we also would indemnify them for the removal of all temporary stockpile materials on the site and any cost for any kind of remediation should there be any contamination on the site, if there is any. We'd also indemnify the city for their attorney's fees arising out of a connection with this. So our attempt is to make the city whole as it relates to these items and to indemnify and hold them harmless. Again, this is a proposal that we have. The detailed and specific language, if in fact this proposal is acceptable to the city, we would work and consider language proposed by your city attorney to the details. But we think we're trying to be as detailed as we can at this point. The next part is the monitoring plan. And the monitoring plan is the nature of various measures that we would undertake that we think would be helpful for both the Redland Company as well as the city as it relates to ongoing operations, should that be the will of the Commission tonight. The first one is that we would, again, provide monthly pit logs. And these logs would be submitted to the city or the engineer of record and or both of them, indicating the approximate excavated amounts of the quarry for the reporting periods. We also can indicate where the materials were taken. We can work with the city attorney or the city staff as to the details of what those would be. We'd also provide monthly excavation reports, and we would submit them to the city and or the engineer of record as well, indicating the approximated depth for the reporting period. We'd also have a site supervisor, which we would also provide and be available to the city, to meet with the city on site during operating hours or by appoint reasonable terms and conditions if there's a need to meet at a special time. We would provide monthly aerial photographs, which would provide the city with additional evidence and documentation of our operations. We would also provide the city, or it actually says a plan, but we would basically bear directly the cost of these items, so that we would provide them with the city all the different monitoring for things. We think this is the nature of a proactive measure that would provide for ongoing reporting and monitoring that your staff and your engineer of record could review and comment upon. And finally, and importantly, we would also provide a payment and performance bond in the amount of $2 million, which we think is a very significant. So we stand behind what we're willing to do, and through that, we've offered this what we consider a more than adequate bond, but that we think is appropriate under the circumstances. So in light of that, we've outlined this proposal. We would ask that you reconsider your action of termination and that you rescind the termination and allow us to negotiate or respond to the terms of any agreement, the details of an agreement that would be consistent with these terms. We believe that it's important to rescind the termination, should that be the will of this commission, and allow us to get back on the site. People may say, well, you cannot continue with excavation or removal until the cease and desist has been lifted by Durham, and that is correct. However, there are things on site that we need and should be doing. For example, we have expensive equipment that we would like to secure and provide security for, but we'd like to also prepare for the reinstitution of the site operations once Durham has lifted the cease and desist. And we also believe that there are things we'd also like to be involved or work with the city in order to expedite the lifting of the cease and desist, and we would offer our experts and our staff to that end. So we are here to answer any questions that you may have. We respectfully request that you reconsider your prior action. We believe that it's in the best interest of both the city and our company to reinstitute operations as amended by the supplemental proposal, the details of which would be worked out and brought back to you if that's your will. I don't think, unless there's anybody else has any questions from Redland or comments from Redland.
Any comments from the council at this point? Any comments?
I got a question for the manager. Mr. Ivey, the list of hold harmless or cost recovered efforts that Redlands put on a supplemental or proposed supplemental agreement, are those costs that would currently be incurred by the city in order to alleviate the cease and desist order?
They cover pretty much all the costs that the city will incur in doing that.
But these are potential outlays for the city to have to pay in order to get the cease and desist or to work towards the cease and desist order being lifted?
That's correct, outside of the monitoring requirement and those kinds of things, but which we would certainly want Redland Construction to pay in the event that that occurs. But either way, whether they are on the site or not on the site.
And that would be part of the detailed part of it that would be worked out in your, if in fact the council were to.
If I'm so instructed.
Okay. Thank you. Thank you, Mayor.
Any other comments?
Mr. Mayor, members of the council, Jeffrey Bass is my name. I'm an attorney. My address is 46 Southwest 1st Street. I represent Atlantic Civil, and I'm here to ask you to do exactly the opposite of what the Redland Company has asked you to do. I also represent Mr. Steve Teresi and Rick Teresi, principals in Atlantic Civil. And I think that a bit of context and history might be appropriate. In 1999, I stood at this very same podium challenging challenging a decision by this city to award to the Redland Company a monopoly, an exclusive no-bid license to work on behalf of the city to excavate a lake and to comply with certain conditions imposed by Miami-Dade County's Department of Environmental Resource Management. That was in 1999. Conduct should prevail over words. People should be judged in their performance of their contracts with you, this city, not by their future promises, but by their past performance, by their conduct. And when you look at the conduct of the Redland Company, the undisputed conduct of the Redland Company, I think it's incumbent upon you to remember one thing. They are your agent. They reflect upon you. Their actions are your actions. And so before you consider the action that they are asking you to take, I would urge you to pause and consider the actions that they have taken in your name. And those actions are simple to recite, but a few are worthy of mention here. For starters, they dragged the city into a hornet's nest of litigation over the original award of the contract. And then at the city's behest, everybody sat down and they promised, in order to resolve the litigation, they promised to do some things, one of which was to abide, quite unremarkably, by the law. We all need to abide by the law, and the specific law that they promised that they would abide by were the conditions of the Durham permit that they stand before you here in violation of, asking you to excuse them once again. The questions from the council were good questions. That is to say, you were looking at the costs and whether or not this proposal would address those costs. But they're your agent under the existing regime. If they've caused you damage, they will pay for that damage, whether you choose to continue to go forward with them and believe their promises or not. The proposal before you encourages the further degradation of the city's name by failing to take seriously the undisputed conduct which has occurred in the city's name. The question before this council that remains unanswered is, why do this? Why do this with somebody who has shown that they're very adept at making promises and even more adept at breaking promises? We would urge this council to hold fast to its studied and reasoned decision to terminate the agreement based on Redland's actions. That's why this city decided to terminate the agreement, not because the city made some decision to do something else. It made a very, very serious decision based on very, very serious conduct. And when you weigh your decision this evening, one which I would urge you to end right here, weigh that decision not based on what you hope for in the future. Make that decision based on what you have in the present in terms of your current indemnification, in terms of your current ability to look to the Redland to recover any damages that they have cost the city as your permittee. And when you're looking at the present, pause and consider the past, because the weather yesterday is the best indication of the weather tomorrow, and there has been no front swinging in causing a dramatic change in the weather. It's the same story. We'll do better, we'll do better, we'll do better. Well, they've had ample opportunity. They've done no better. We would urge you to hold fast to your prior decision, to hold to the termination, and to reject the proposal that's before you this evening. Thank you.
Mayor.
Councilman Bell.
Thank you. I'm sorry. What was your name, the attorney?
My name is Carrie Barsh.
I'm sorry, his.
Oh, Mr. Bass?
Mr. Bass, thank you. You know, it's interesting. I'm currently reading a book on leadership, And one of the compelling statements that's been stated over and over in this book on leadership is that, and Winston Churchill also stated it, that the best predictor of the future is the past. The best indicator of future behavior is the past behavior. That's a guarantee. Now, I think that maybe we should be cautioned here tonight, and I want to say council has taken action, and it's been tough. Council took action at a committee of the whole, and council took action at a council meeting. Council did the right thing, and it did the only thing it should do, and it did the only thing it could do. And I think that we need to look to our city manager, number one, for a recommendation from the city manager. And then number two, I think we should be cautioned because, Mr. Attorney, am I correct that there is a threat of litigation if we do not allow him back on?
Yeah, actually, depending upon what you decide, there could be litigation from either side.
Right.
So I do think that you should deal tonight with the substance, with the concept of whether the council wishes us to enter back into negotiations with the Redlands companies or leave it the way it is, as opposed to getting in details in terms of who did what to who and so forth, because depending upon, I don't know how this is going to turn out, but it could hurt us from one way or the other. So just I would deal strictly with the decision of, are you comfortable with your prior decision, or do you want to reconsider it? That should be the only issue, really, that should be discussed.
Thank you. And Mr. Manager, what is your recommendation for this council?
Notwithstanding the lawsuits and things that are going on outside this particular decision, I am remaining with my recommendation of defaulting the Redland Company on this project.
Thank you very much.
Is that it?
Well, I also wanted to, I don't want to get into all the minutiae and the details, but I would just like to say that the proposal has offered nothing more than what they would have to offer anyway. Nothing has been offered financially other than what would have to be offered. Of course, with no mention of repaying for the over-excavated fill. There's been no offer to pay for the fill that's been over-excavated and sold. There's also been no mention of all of the times that fill has been removed from outside the DRI. So I don't really want to get into that at this point because, like I said, I think we are going to end up in litigation. I think that we need to just move the recommendation from the city manager and close the meeting because we are going to enter in litigation. And I do move the recommendation from the city manager.
There's the city's already taken action.
That's correct. That's right.
So that if the council doesn't take any action, we're going to remain in the current posture where we are. In order to change the prior action, you would need a motion. I don't think your motion is necessary.
Correct. Thank you.
Mr. Mayor, yes. May I be allowed a brief rebuttal?
Sure.
I would like to respond to some of the questions and some of the issues that were raised, if I could, just for a minute. One of the things that Mr. Bass referred to was context, and in fact, I want to just, as you may be aware, just to let you know that in 1999, one of the conditions that was regarding this exclusive license was that the Redland Company came forward with over $1,426,000 that the city was in dire need at that time. So I think that should be, when we talk about words and action and promises, the company came forward at that time showing their good faith. In addition, there was a lot of talk about the matter that we're an agent and the way we cast or how we're viewed. I do this for a living, and I can tell you that I don't know if anybody in here can say without a doubt that they've never violated the law. They've never speeded. They've never done anything inconsistent with the law. We're not saying that what we're saying is we're going to respond with this. We're going to address these permitting issues, and we're going to go forward and do the right thing. The proposal that we have right now is in excess of what we would otherwise be obligated to do under your contract. So I disagree with that assertion. I think it is better than what you would have right now if the termination were to remain in effect. And I just want to also say that we do believe that we have a right, regardless of what happens tonight, regard the existing fill material that's on the property. So we would like you to consider that as well. We're hopeful that you will consider the best term long in for everybody, which is to get the site, the cease and desist lifted and allow us to proceed as expeditiously as possible so that you and we can get back on the site, secure our equipment, prepare for site resumption of site activities. Thank you very much.
Yes, Mr. Hodge?
I would like to go ahead and say that after looking at this situation and really reviewing it and talking it over with the city attorney, I really was analytical about the whole process and the way I viewed it. I mean, and this is something that we can keep in our mind. To me, it's more of an economic decision, and most of us wasn't around in 1999 when this agreement was made, and we all know the conditions that the city was in at that time that this particular agreement was made. I think, number one, this will give us an opportunity to take a second look at that agreement. And number two, if we decide to go ahead and terminate and bring in a new contractor, based on the litigation that we may have to go through in that process, although we may have good ground, the time and the expenses of finding that ground, we would need to look at whoever we decide on bringing in, what type of agreement that we're going to make with them, just making good business sense to make sure that we can recoup those litigation losses as well as maintain a profit and be in good standings and in a positive standing with whatever decision we make. And whoever comes or whoever we decide to make that agreement with may not agree to those type of terms because that may be a I would say, have more teeth in that agreement than what they would be willing to receive. Also, again, we can go back and revisit the current contract and be able to put more teeth in it. And again, most of us sit on the council now was not there when this agreement was made. And in a sense, I kind of fault us because we should have had some type of monitoring agreement where we were in control of the monitoring in the first place.
Excuse me, Councilman Hodge. Councilman Hodge.
Councilman Hodge, the attorneys that want to address you.
Yeah, Councilman Hodge, I really think we should stay away from a detailed discussion of what the city should have done or shouldn't have done, because I think it may come back and bite us. Were you able to hear that? Okay, so I would just sort of stay away from that, what one party did or the other party did.
All right, so thank you. So basically what I'm saying is economically, I think it would be feasible for us to just go ahead and take a second look at this agreement, put more teeth in it, and also put in there where there are, and they put it in agreement already, but we make sure that there are some monitoring key points in there that we receive that report as well as dorm, so we have more of what's going on, and take a little bit more part in there. And I think there's an opportunity here as well for us to get a little bit better agreement. I think we have a better playing field that we can get a better agreement out of the situation. So I don't think all is lost, but I think economically this will be a better path for us to take. And the reason being, again, going through a long-term litigation process and having to deal with this issue and still try and move the field at the same time, I think would really complicate things more than we would like it to do, because it would affect the growth of the city in many ways, and we know that it is tied to other individuals as well. It's not just our field. So I wouldn't want our growth to be hindered, as well as we try and go back and negotiate with another individual. I think we can make the best of what we have and put more teeth in our agreement.
Thank you, Councilman Hall.
Mayor.
Mr. Losman.
Thank you. It's occurred to me that the main focus of the Redlands presentation tonight is geared to, number one, the removal of the currently excavated fill, and number two, the securing or the removing of, and I acknowledge, some very expensive and high-maintenance equipment that's on site. And I can't sit here and reconcile that tonight that it is necessary to reinstate the agreement in order for there to be some resolution that Durham is an indispensable party to the resolution of when and how the existing excavated material is removed and how and when the equipment is secured or removed. I mean, if the council wants to address an agreement, certainly it's got the discretion to do so in the future. But the main focus, as I perceive it tonight, really is independent of whether or not the agreement is reinstated. And I would think that those two issues, the currently dug fill and the equipment, can be addressed in the absence of whether or not the operating agreement is deemed to be terminated or not.
I agree.
Thank you, Mayor.
Thank you, Mr. Lawson. I need to ask you a couple of questions. Yes.
Yes, Mr. Mayor.
I read this thoroughly. What assurance the council have that the mistakes that were made in the past would not be repeated?
The monitoring plan section and the bond, the monitoring plan provides a series of checks, ongoing checks, to ensure that the permit conditions are complied with. Those ongoing checks include the aerial photos, the on-site supervisor, the monthly quarry reports. All those things are intended, and obviously if there's anything else that the council suggests, we would entertain to ensure that the mistakes of the past would not be repeated. We believe that those things are things that would do all well, and you also have an independent third party, Durham, who's going to approve, assuming they lift the cease and desist, which we have every indication that they will evaluate and approve the monitoring plan. So we believe all those measures are measures proactive that will in fact avoid the mistakes of the past. And again, we would consider, should this be the will of the council to proceed, consider additional measures as you might propose or your city staff might propose.
Because of the mistakes of the past, would it not be suggested that the monitoring plan fall under the umbrella of the city, paid by Redlands, that the reports are provided through the city to Durham and Redlands and whomever else is, because I would have difficulty accepting anything without this monitoring plan being solely under the city's jurisdiction and not under Redlands' jurisdiction.
I think that's, and I have to consult with my client, but I think that's something we would agree to.
Mayor.
Councilwoman Bell.
Thank you. I was kind of hoping we wouldn't get into all this, that we would just adjourn and discuss this in the executive session, possibly if it doesn't look like it's going to go that way. I, quite frankly, cannot even believe that we would even consider reversing our termination. I cannot even fathom that. And I'm quite frankly sick to death about hearing how the Redland Company bailed out the city, because I have asked for complete calculations from our finance department, and the Redland Company has more than received their money back, including times when we had to sue the Redland Company just to get compensation where we were entitled. More than the amount. And I think anybody, quite frankly, would have loved that agreement to bail the city out for that amount, for what they got in exchange. So we don't even want to go there. Now, this agreement, and boy, this proposal, and boy, did I analyze it. As far as A through I go, Redland Company is going to have to incur those costs anyway. They are costs that are going to be borne by Redland, whether it's litigation or not. Now, when you look at H, actual cost for the removal of all temporary stockpiled material brought onto the site, without permission of the city as well, with the continuation of removal after the cease and desist permit had been enacted. And that is asphalt. It was never supposed to be there. And even in here, cost for contamination remediation, when it wasn't even supposed to be there in the first place. I am appalled. I am absolutely appalled. And let me just throw the word out, mistake. You can't mistakenly add drag line to go deeper and deeper and deeper. That's no mistake. It's purposeful. You can't mistakenly remove thousands of truckloads outside of the DRI in order to make more money outside and violate not only the Durham permit, but the city's agreement. I mean, I could go on and on, but the violations have been occurring for 6 years. And I am appalled that we would even consider or fathom. It is like, fool me once, shame on you. Fool me 5,779 times, shame on me. I mean, this is absurd. I think that we need to continue. We do not need a motion to continue, but I'm just appalled. We don't even have the results yet from whether we have saltwater intrusion or not. We don't even have that. No promise in this proposal to end the removal of, and by the way, there is an agreement already that's been violated over and over and over, but suddenly now we're going to obey the agreement. Suddenly now, after 6 years, now that we've been caught again, now we're going to obey. Now we're going to put monitoring methods to make us obey. I mean, this is like the proverbial child with their hand caught in the cookie jar, but now we're going to do it right this time. I am just appalled. Like I said, we don't even have the results of the testing for saltwater intrusion. We have overdigging all over this site, and you know what? I have never even had an offer of the finances returned back to the city for the sale of the overdug fill. Because if we were to sit down and calculate the loss of fill that was sold off-site, that went below the 52 feet, I mean, it could be $2 million. It could be $3 million. There's no attempt to repay the city for the overdug fill. I can't even believe that we're here, to be quite honest. We've had the proposal from Redland. I think that we should adjourn the meeting, and I really think that we should take this to executive session and hammer this out. And I also think that we need to accept the recommendation from our city manager. That's why he gets paid. He is doing the absolute right thing, and this is tough. This is tough for the city manager, and council made a tough decision, and I admire the council for standing strong and standing firm in light of the friendships in the community, and I'm aware of the friendships in the community. But we are charged with the caretaking of the city assets, and doing the best thing for the city, and we need to continue and proceed as we originally started.
Any other comments? Mr. Porter?
Mr. Attorney, let me ask you a question, and if it's inappropriate, just tell me it's inappropriate. But a comment was made by Councilman Hodge referencing a potential future bid out of, assuming Redland is removed from the pit. How does someone get on the pit? It's a very, very critical part of this whole equation in my mind, because I was one of the ones that was there in '99, and I've seen this thing go from the whole gamut, a very, very difficult situation all the way around. It's always been on shaky ground, and so I'm sensitive to that part of it. But I don't think the whole city involvement back into the whole equation of bidding out is appropriate. I don't want to go that route again. Is that a bad question or a good question?
I think it's sort of a bad question. As you know, I think you knew it was sort of a bad question. Okay. As you know that there's an issue still involved in that, and of course I'd be glad to discuss it with you. If we stay where we currently are, obviously we have to deal with how we're going to move forward with with this asset. And I'd be glad to, discuss that with you, but I think I should stay away from discussing it this evening.
Well, with regards to the cease and desist and how, when it was brought to my attention that the manager was proceeding forward, I spoke to the manager independently and went upon his recommendation, and that was what we voted on the last time because the manager was upset. Since then, I've had individual attention from the attorney's office. Other issues have come to light, and certainly I'm sensitive to the manager's position. But at the same time, this is really a policy decision that can be made above the manager's recommendation. We've been doing it for years, sometimes for the better and sometimes not. But to pull the trigger as quickly as we did on the cease and desist, I went on the manager's recommendation. Now it gives us a chance to take a little bit harder look at it. There's extenuating circumstances to it. And so I'm grateful for the opportunity to be here, Mayor, and for the opportunity to hear more than the manager's frustration in the cease and desist. So I'll yield to you, Mayor, and any other questions from the council, but I think that this is an appropriate way to find out all the facts, or at least more of what may be out there. And the attorneys with Gail and Michael being able to come down, I appreciate the opportunity to sit with you and at least get some independent opinion on this. So I thank you for that, and Mayor, I'll give it back to you to see if anybody else has any comments.
Thank you, Mr. Porter. Any other comments from council?
Mayor, I'm glad we're here discussing this again too, because we were not allowed to have discussion, as the discussion's been cut off several times tonight. I made a decision based on what the manager told me, and then separately met with the attorneys because we couldn't discuss this publicly. This has been very difficult. We can't talk about half the things on the dais. I don't know that I would have made the same decision if the meeting was today that we had. Especially today, coming in here and hearing today that no matter what we decide, we're going to get sued by somebody. That really doesn't give me faith in anybody. But I've just not been happy with this the whole way. I think we should have met with the attorneys before any decisions were made, because I think we made a decision in haste. And I don't know what the best end result for the city is, but right now, we're looking at 2 litigations and no fill. I think the fill is the most important. We need to be, filling up our substation at the Park of Commerce. We need to be giving Shores their fill. I don't know that the termination is the best thing.
Thank you, Councilman McGarner. Councilman Roman?
I just have a question. When I met with the attorneys, I asked a question, and I'd like to ask it again. Is there any reason why Durham would not work with Redland Construction, or is there? Because I wasn't at the meeting that all this was taking place.
Councilwoman Michael Popak with Weiss Sirota. When we met with Durham, Mrs. Sirota and I, they did not give us an indication that they would be loath to work with Redland again. It's not a policy decision of Durham. We were meeting in a kind of a workshop session, but they did not inform us that if the city moved forward with Redland, that would be a no-go from the Durham perspective. But they were also, I don't think they were going to be in a position to make that kind of decision at the meeting that we were at either. But
in your opinion, from what I gathered when I was meeting with the two of you, in your opinion, I came away thinking that they were not going to discriminate one way or the other as to who is in the position, whether we hire somebody else or whether we keep them.
I think their position is that the city is the permittee, and it's its responsibility to resolve the problem that's been created by Redland. And but in terms of your question, they're not. We did not get an indication from the division chief that if Redland were still involved with the permit, that would be a problem with Durham.
Well, unfortunately, like I said before, I wasn't at the meeting that this was decided upon, but I will say this, I have read this over and over, as I'm sure all of us have, and this is a very difficult position to be in. However, I know that we would never and then I'm not going to go there with what you did, what you didn't do, bad boy, spank my hand. I'm just not going to go there at this point, based upon what the attorney said as well. But I just want to make a comment, and that is that I doubt that we would ever have the negotiating power that we have right at this moment with any other company, as far as monitoring and knowing exactly what's happening. And with the city being the permittee, that I think that that's a scary position for us to be in, not knowing what's happening. I believe that's where the mayor was going when he asked who would be monitoring. And do we get a decision on that? It would be the city that would be monitoring, based upon costs that would come from Redland Construction?
We would willingly modify our proposal to have the city do the monitoring, and we would indemnify you for the cost associated with that.
Thank you, Mayor.
Thank you.
What's the date of completion of this project? Estimated date of completion of this project? When?
Mr. Mayor, we have Ed Swaycon here representing us, working as our engineer on this record.
What's the estimated completion date for this project? When would we pretty much excavate the field out of that ground, and we have this behind us and we move forward? You got any general idea how long it would take for this project come to an end?
Right. My name is Ed Swaycon. I'm the president of EAS Engineering, and I'm your environmental consultant handling some of the negotiations with Durham. I'm not sure that I'm the appropriate person to actually give you the build-out date. I can tell you that you have permits that expire. The Durham permit was just recently renewed for an additional 2 years. That's a consideration in terms of the renewal of the various permits. Compliance with those permits is always something that's looked at. But right now we have a permit from Durham that would go for an additional 2 years. Whether that's enough time to actually complete the excavation, it really depends on how fast someone does the work.
Thank you, sir.
Excuse me, Mr. Mayor.
Yes.
Under our agreement, the license, Redland's license, terminates upon the earlier of 3 years after 90% of the available fill has been removed from the lake site, or January 1 of 2015. And these agreements contemplated a removal of a total of 5 million cubic feet, I think. Sorry.
Mr. Vice Mayor.
Thank you. As I listen closely to my colleagues tonight, I get the feeling that the majority here are going to give some sort of direction to the manager. And if that's going to be the case, I think we need to be very careful and make some fine line distinctions. I think the request here tonight is to rescind the notice of termination. Is that correct? Effective tonight?
Yes, sir, that is correct. Reconsider your prior action, terminating the agreement and rescinding the termination.
That can't happen tonight, because this is not a council meeting. The most that the council can do tonight, would be to direct. My suggestion would be to direct staff, if that's what the council wants to do, to negotiate an agreement with, an amendment to the agreement with Redland, and bring it back to a committee of the whole and then a council meeting. And then part of that would be rescinding the termination.
And that's what I was getting at, that if we could legally, and I want to be real clear, it wouldn't be with my vote tonight, to rescind the termination, I think that would be very premature.
I wouldn't recommend that at all.
There are too many unknowns. Now, if the majority wants to send the manager to the negotiating table, I think that's an important distinction to be made from authorizing out of hand a rescission of the notice of termination. But quite frankly, I believe that any negotiations are premature. We don't know what the Durham conditions of reinstatement of that permit are going to be. We don't know the nature and extent of remediation. We don't even know what volume of fill remains to be excavated under the original permit that allowed, what was it, 5 million total? 5 million cubic yards total. What's the correct terminology? Assayed or surveyed as to what's left based upon the over-digging. In my mind, there are too many unknowns to even begin negotiation. And for that matter, what good does it do to rescind the termination when the Durham cease and desist order trumps, at this moment, and until at least the middle of April, I'm told, trumps anything that anybody would want to do. To me, there are just too many unknowns, and to rescind it and say we're going back to the drawing board, I think leaves the door wide open for the city to lose the opportunity for some tremendous financial opportunity. I think we could find ourselves being left holding the bag.
Absolutely.
If the rights of the current operator were conveyed to someone else during that interim period. As long as this agreement remains terminated, I think our position has been is that the operator has nothing to sell. So I think we need to be very careful, for those of you who are sympathetic to revisiting this issue, as to looking out for the good of the community and not the personal good of a private operator who, my manager stands by his comments that the defaults were purposeful. And I don't see any penance being offered up here. I don't see anybody asking for any penalties. I don't see any mea culpas. Let me pay for my mistakes and move on. And now we have at least 2 other parties that are in our business because of what the manager has termed and stands by his term of purposeful breaches of the agreement. And y'all can stay PO'd at me for another month. But to let this skate again is a breach of our duty to the taxpayers and the financial well-being of this community. Thank you, Mayor.
Thank you. Mr. Hodge?
Yes, I just wanted to address, if I read the proposed agreement correctly, I think on the financial impact that the city would incur is addressed in that. That's great. And it also addresses the fact based on what may happen with the re-permitting or reopening the permit for the field. And I think in the proposed agreement, which I would even like to make a little bit stronger than what's proposed, addresses all the income issues that the city would incur and have, and also any future finances that the city would have to pay to them in the event that something, there extra permitting fees or fines that may come up in this case, and based on that is one of the reasons that I am basing my decision and my choice, because the goal here is to protect the city financially, and if this is an agreement, then that means the city will not incur any cost in reference to this particular issue, as well as have an opportunity to negotiate the current agreement and make it stronger and more profitable for the city. So all those issues that was brought forward to us, to me, have already been addressed in the proposed agreement. And I would hope if we move forward tonight that we can even make that a little bit stronger, so that we can make sure that all those issues are addressed for our future security.
Thank you.
Mr. Mayor, I'm sorry. Just if Yes, my name is Carrie Barsh again. If I could, I'd just like to put in the record, since we were not, my client wasn't aware of the meeting when this was discussed in December, we were not in attendance at that council meeting, and we do want to state on the record, lest it may look like my quiet or my absence lets it, that those were not purposeful violations. And so we would have, had we been here, we would have addressed this more in detail, and I've kind of tried to stay away from that looking forward, but since it's been stated on the record several times, I do feel the need to address that. I also want to just say that in response to the Vice Mayor's issue about penalties and the penance and all the like, our supplemental agreement proposal would address those. At least we thought that we'd address those penalties, any kind of cost associated with this. And obviously, if there's language that would make you more comfortable that the city wants to propose, should this council agree, we would certainly consider that. That was our concept, that was our intent. So thank you very much.
Thank you.
May I ask a question, Mayor? I'm sorry. Just got for the attorney, Mr. Weiss. The request from Redland is to rescind the original motion that we voted on. You said something to the fact that we couldn't do that here.
No.
So why are we here?
It's a special council workshop meeting for you to. The way this came up is there was a request by Redland to address the council. They've addressed the council. To the extent that you want to give your staff any direction as to how you want to proceed from here, that's what the purpose of the meeting is. If there's no further direction, then somebody should move to adjourn and we should move on.
Does the cease and desist not allow the manager or Redland to work towards some amenable resolution to this problem? Because it was my understanding or my interpretation that the cease and desist, no more conversation, you're over, adios, out the door you go, and we start over again. Now, I'm getting a little confused.
I'm wondering, and maybe Michael or Gail can help me here. I'm wondering whether whether there's two things that are going on here that sort of sound the same. One is a termination of our agreement with Redland. That's been done, and that was pursuant to the council's instructions. That's one issue. The other issue is a cease and desist order that was issued by Durham.
So the only thing that we can speak to tonight would be rescinding our termination agreement with Redland.
That's correct. And the only thing that you could do tonight would be to direct staff to explore negotiations with Redland for an amendment to the agreement, which, if it was approved, part of that process would be rescinding the termination. That's the most that you can do tonight.
Okay, the termination agreement is in place by Durham.
The cease and desist.
I'm sorry, this
is in place by Durham. Correct.
And our agreement was terminated at the same time, at the same meeting, I believe.
No, the cease and desist. Correct me if I'm wrong, but the cease and desist was issued by Durham, I believe, before we terminated our agreement with Redland.
At least 3 weeks before, 2 or 3 weeks before.
But that cease and desist, whether we needs to be dealt with, whether it's with Redland or with another contractor, as Michael Pobach said, we're the permit holder, so that's going to be an issue that the city's going to have to work through either by itself, with Redland, or with the new contractor. The issue with Redland is separate from the cease. That's obviously intertwined, but the issue of whether you want to take any action tonight is independent of anything that we can do on the cease and desist. We can't take any action tonight that would affect the cease and desist.
Okay. Well, I just want to put on record that some comments have been made about what you do up here being for a private industry or for the good of the city, and certainly I just want to put on record that every decision that I make up here is not done for any private citizen. Those kind of comments, I think, should be taken up with the newspaper, because that's a sensationalism that they would want to put. But I think everyone up here, I speak for myself, everyone up here I think we're all trying to do the right thing. We're all trying to work through this mess. We're all trying to work through this maze. So, it's a very difficult situation that we find ourselves in, and Mayor, I'll go out on a limb. We got 20 minutes before the next meeting. I'd make a motion that we reconsider the termination agreement with Redland and direct the manager to come back with some sort of amenable settlement for the council to look at.
Unbelievable.
And within a time frame of 2 weeks.
Yeah, if I could I would just like your motion to say rather than reconsider, because that's a technical term under Robert's rules, I would like you to suggest that you'd like to say that we discuss rescinding our termination with Redland. You would direct staff to discuss an agreement with Redland under which the agreement would be modified, and if that was approved, then the termination would be rescinded. I don't think I said that very well.
Mayor?
If you can't say it, then I certainly can't say it.
All right, let me try it one more time. Basically, what you're going to do is direct staff to commence negotiations with Redland for an amendment to the agreement, and as part of that, to come back to council with an agreement, and part of that would be reconsideration of our termination of the agreement with Redland. But we're not doing it tonight. It's just a direction to staff.
So I need is that in the form of should I do that in the form of a motion?
Yes.
And that's my motion. Okay.
Is there a second to the motion?
I'll second the motion, Mayor.
Second by Councilwoman Garner. Councilwoman Bell?
Thank you. I have a question, procedural question. I was the original maker of the motion at the council meeting, and as the original maker of the motion on the prevailing side, I'm the only one who can actually undo that motion. So are you just looking for a new separate motion? Because the contract was terminated. It was terminated at a committee of the whole. It was followed through at a council meeting. There was a motion moved. It was unanimous both times, and I am the prevailing side. So how does somebody undo the original motion and the original maker of the motion when I was on the prevailing side?
At this point, all the council is doing is directing us to start negotiations with Redland and bring it back to the council. It would be listed as a separate item on the agenda, which would be a motion to reconsider something previously approved, which if it's listed on the agenda doesn't need to be done by the prevailing side or the maker of the motion.
I just want to continue to state my objection. I think council did the right thing the first and the second time. I don't know what changed. Our information has not changed. I don't know what changed since the last council meeting. It just boggles my mind. I'm not going to say anything further.
Thank you, Councilman Bell.
Mayor.
Mr. Vice Mayor?
After that attack, I think I need to clarify what I was saying. I think I was making a distinction between the benefit that could potentially accrue if we didn't recognize, if we had the ability tonight to rescind the termination, it could put the city in a much worse situation. I never meant to indicate that any action up here was intentional to be for the benefit of a private party. My comments were that we needed to be real careful to make that distinction and not unintentionally put us in a situation where benefits that could come back to the city in further negotiations would be lost. And to suggest that my comments are to play for the newspaper, I think those are enough said.
I apologize for my misunderstanding.
Thank you, Mr. Vice Mayor. If there's no further discussion, and we have a roll call on this question, Madam Clerk?
Vice Mayor Losner?
No.
Councilwoman Bell?
No.
Councilwoman Garner?
Yes.
Councilman Hodge? Councilman Porter?
Yes.
Councilwoman Waldman?
Yes.
Mayor Warren?
Yes.
Motion carries.
The special workshop is adjourned.